Hello, everyone. If you've just joined us, welcome. If you weren't excited about the prospects for change in our country before this morning, I know that after that spectacular first panel on law and justice policies in a new administration, you now are. I want to add one thing, which is that we are a 501c3 organization, and as demonstrated by the great amount of agreement on that panel, the ideas expressed are obviously super ideas for whoever the next president might be. We have a lot of thought-provoking panels over the next couple of days, but we are very excited right now to welcome Senator Patrick Leahy as our keynote speaker. Senator Leahy understands that our constitutional system of checks and balances is critical to our nation's health, and that law and the courts have a direct impact on people's lives. He is a true friend of ACS, working every day to protect that system of checks and balances and also to protect the rights and liberties at the heart of our Constitution, fighting particularly recently to restore the right to habeas, a position that was thankfully vindicated yesterday by the Supreme Court. Senator, we are very honored to have you here, and I now want to welcome Nandi Campbell from the University of Georgia to introduce the senator.
Good afternoon. My name is Nandi Campbell. I am the immediate past president of the University of Georgia School of Law ACS chapter. Welcome. It's my pleasure to introduce Senator Patrick Leahy to the ACS convention. Senator Leahy is a graduate of Georgetown University's Law School. In 1974, at the age of 34, Senator Leahy was elected to the United States Senate and has been re-elected 5 times. Senator Leahy is the chairman of the Senate Judiciary Committee. He headed the Senate's negotiation in 2001 on the Patriot Act and succeeded in adding checks and balances to protect civil liberties. In 2006, Senator Leahy was one of only 10 senators who voted against extending the Patriot Act for similar reasons to protect civil liberties. Senator Leahy is also chief sponsor of the Innocent Protection Act, which addresses flaws in the administration of capital punishment. Part of Senator Leahy's death penalty reform package, which was enacted in 2004, reduced the risk that innocent people are executed by providing post-conviction DNA tests and better access to competent legal counsel. An advocate of privacy rights, the Senator chairs the Senate Democratic Task Force on Privacy. This task force held their first hearing in 1994 on privacy concerns relating to electronic medical records. Senator Leahy's commitment to public service is truly inspiring to me, and it's an honor for me to introduce Senator Patrick Leahy.
Thank you. Thank you very much. It is nice to be here with lawyers and others I feel comfortable with, and members of the, from my office in the Senate Judiciary Committee. Why don't all those who are here from the Senate Judiciary Committee please stand up? I don't mean to embarrass you, but thank you. The reason I do that, we senators are merely constitutional impediments to the staff, as they've heard me say many a time. They're the ones who do all the work. I get the credit, and I want to make sure they get the credit. In fact, it's an interesting time when we're in the country today. We're fortunate that we have so many good men and women who are willing to serve on the Hill or serve in government and give so much of themselves to make the country we really love and the Constitution we really love. I mean, we're focusing on the two presidential nominees and the different paths their presidencies would take our country, but I think that we have to focus on the fact we have to keep the country going between now and January 20th. So let me focus on the impact presidential appointments to our courts have on all Americans. I say this because when the President takes the oath of office on January 20th, whoever that is swears to uphold our Constitution, including the appointment of judges. And I want to make sure that when the oath is taken, we have somebody who has read the Constitution, understands the Constitution, and will follow the Constitution. We'll each have to decide who might best fit that category. But I look at the Supreme Court's recent decisions, and I think they dramatically underscore why the selection of judges to our federal courts impact the daily lives of real people, even in matters of life and death. We hear very little during a presidential campaign about the selection of judges. It is a critical part of who is going to be president. The American people need to be able to trust their courts are going to uphold their rights and not play favorites, depending upon what your political background might be. And as lawyers, as leaders, we all need to do a better job of translating the court's legal theories and the technical and procedural rulings, which are so dry to read, but projected into what they are in real-life consequences. The time to energize and educate the public about the impact of the court on their lives is not after the next election and after the new president has nominated a justice to the Supreme Court or a Court of Appeals judge. We have to do it today. Now, I recognize Supreme Court rulings tend to receive national notice only when they involve divisive cultural matters. Lately, however, many of us have noticed that business interests have been the big winners, often at the expense of ordinary Americans. In this very worsening economy, and you should hear the tales I hear each weekend when I'm home in Vermont of what this is doing to good, hard-working Americans. Mothers and fathers are struggling with health care coverage, the uncertainty of retirement, credit card payments, mortgages, say nothing about the high price of gasoline. And Congress has passed laws to protect Americans in most of these areas. But in case after case, the United States Supreme Court has ignored the intent of Congress in passing these measures. Oftentimes, activist judges, activist conservative judges on the Supreme Court have turned the laws on their heads. Instead of making them as protections for average Americans, they've made them as protections for corporate defendants. One recent example is the case of Lilly Ledbetter. Let me tell you about Lilly Ledbetter. She worked for more than 2 decades as a sole female supervisor in a major national corporation. Shortly before retirement, she received an anonymous note showing the salaries of men doing the same kind of work in that corporation. Even the lowest paid male supervisor was earning 20% more than she was for the same job, even though they had less experience, less seniority than she did. It turns out she'd also been shortchanged on bonuses, retirement benefits, and overtime pay. Now, Ms. Ledbetter proved to a jury that she'd been illegally discriminated against. As lawyers, every one of us knows it's a blatant case of discrimination. But the Supreme Court, the U.S. Supreme Court, stepped in to reverse the verdict, creating a bizarre interpretation of the law. Her employer will now never be held accountable for what was illegal actions that they knew were illegal. In addition, the ruling tells other corporations they can discriminate with impunity so long as they keep their illegal actions hidden long enough. This was never what the Congress intended. 2 days ago, I called a Judiciary Committee hearing to shine a light on several decisions in which the Supreme Court, in an activist fashion, has overridden congressional intent and misconstrued laws designed to protect ordinary Americans. We heard from two very brave women, Bridget Robb and Maureen Kurtek. Both are denied justice for the grievous injuries they suffered. Ms. Robb almost died and suffered great pain as her implanted medical device malfunctioned. And she described it as feeling like just constantly being pounded in the chest with a hammer as electrical shocks went through her body. And as you listen to her terrified 911 call, you can hear her 6-year-old daughter saying, "Mommy, don't die, don't die." Ms. Kurtek, the other person, suffered amputations and multiple organ failure when her HMO would not approve timely treatment. They kept saying, "We'll get back to you, we'll get back to you, we'll get back to you," for months until she nearly died. And then they said, "Oh yes, you're entitled to the treatment." By then she had lost part of a foot, she had had severe organ damage, lost parts of her fingers. As she said, "You know, my husband and I like to go dancing. I'm too ashamed to go dancing with this prosthetic shoe I have to wear now." There are thousands more like them. They're being adversely affected by rulings that slam the courthouse door shut. Now, years ago, Congress passed a landmark law known as ERISA. It was done to ensure that workers with employer-sponsored health insurance or retirement benefits could count on them. It was a tremendous accomplishment of the Congress. It got bipartisan support. But the Supreme Court, has so distorted this law that it provides no relief for individuals when the companies entrusted with administering their benefit plans violate the law or the terms of the plan. And moreover, the Court has held, and I believe wrongly, that it was the intent of Congress to take away pre-existing state law remedies for workers. So basically what they're saying, the Congress intended to make workers less safe than they were before the law. No person who voted for this law ever intended that, and the courts know it. From the late Justice White to Justice Ginsburg, this misinterpretation of the law has been decried as preposterous, unjust, incompatible with Congress' true intent. As one judge observed, the Supreme Court's interpretation of the law has turned ERISA into a shield that insulates HMOs from liability for even the most egregious acts of dereliction directly contrary to the intent of Congress. You won't find many members of Congress who said they wanted to vote to shield HMOs from dereliction of duty. The Supreme Court narrowly interpreted another law designed to protect the thousands of Americans who rely on medical devices like Ms. Robb, who was nearly killed by the electrical shocks. Here again, the Supreme Court's interpretation has transformed a law intended to do something good into one that takes away protections from people. But I think even worse, it encourages corporate misconduct. The Court has again decided to extinguish long-standing state law remedies that hold corporations accountable. Now, most people probably want to do the right thing. But in the 8 years I was a prosecutor, I always knew that there were some who did the right thing only because they knew they'd get in trouble if they broke the law. Well, now the Supreme Court has basically said, if you can get away with it, you got our blessing. Then there are the laws governing lending institutions used by Americans to finance their homes and credit cards used for everyday purchases. In this context as well, the Court has interpreted federal legislation in a way that strips consumers of the right to benefit from more protective state laws. That also shields corporations from misconduct. Now, I mention these Supreme Court cases because they didn't get much public attention. But walk down the street out here, and you bump into dozens of people who are affected by them, usually adversely. So we have to look at preemption, which is now being increasingly used both as a sword and a shield. The Supreme Court has traditionally considered there to be a presumption against a federal law preempting all state law, and for good reasons. Excuse me. First, our government is structured on important principles of federalism which respect the rights of states to govern. I'd like to give this lecture to some of those who say, oh, we got to go back to original intent. Hell, I'd be happy if they did. If they did. We've got the most activist, conservative Supreme Court justices in my lifetime. Our states have traditionally played the primary role in protecting citizens' health, safety, and welfare. That's why federal regulations are viewed generally as setting a floor for conduct, but the states are allowed to be more protective of their residents. The touchstone of preemption analysis is the intent of Congress, so one would not expect sudden assertion of wholesale preemption decades after Congress has passed a law. Why all of a sudden, to decades, wait, oh, I remember. There's an aggressive administration playing to its allies on the Supreme Court, and that's exactly what we are seeing. There's an important preemption case in the court's docket in October. It involves a children's musician from Vermont named Diana Levine. I know her very well. 8 years ago, she went to a hospital for a treatment of a migraine headache. She was injected with a drug to treat nausea. Because of the way the drug was administered, it entered the arteries in her arm, causing an infection. She's a musician who plays the guitar. The infection caused her arm to be amputated. Wyeth, the drug's manufacturer, was well aware at the time that arterial contact with their product could cause severe injury. Diana sued Wyeth, and a jury of her peers, and we have fairly conservative juries in Vermont, awarded her $6.7 million. And a conservative Vermont Supreme Court upheld this determination, holding that her claims were not preempted by federal law and FDA regulations. Not surprisingly, the Bush administration, with nothing else better to do, urged the U.S. Supreme Court to grant review in Diana's case and reverse. Remember, these are the people who say we've got to protect the rights of states. Well, unless they violate the rights of our contributors. I can say these things. I'm an elected official. And you know, one of the parts I like about the Constitution, the part that gives senators a 6-year term. And one of its primary arguments is based on a radical departure taken by the Bush administration's FDA 2 years ago. For decades, the FDA had consistently recognized that its labeling rules created minimum requirements, and the state common law claims that coexisted with federal regulation of drugs. Both Democratic and Republican administrations agreed with that. But when this administration came in, they radically departed from well-settled administrative and judicial views on this issue. For more than 70 years, Congress has legislated in the area of food and drugs knowing that federal law does not preempt state failure to warrant claims. It's long been understood that state tort law complements federal regulations. And suddenly, this administration, the unitary view of government, that they are the law, they override anybody else, their assertion that their regulations suddenly preempt all state common law actions is a blatant power grab. In a case where congressional intent should be the operative issue to determine preemption, it's unclear whether the court's going to defer to Congress or to this sudden, unprecedented change of 70 years of precedent action on the FDA. These are very, very troublesome things. When I was in law school, as I did in college and in high school and even grade school, we learned about 3 branches of government. And we learned about They coexist, they're equal, and so on. Now we have an administration that says we want our word to be the final word, and the courts had better get in line to do that. Now, I would be remiss if I concluded without mentioning another important Supreme Court decision, which is going to have a powerful effect on the rights of all of us. Yesterday, the Supreme Court did the right thing when it handed down Boumediene versus Bush decision. It upheld the Constitution. It held up the great writ of habeas corpus. I was chairing a Senate Judiciary Committee hearing when I was handed the news. I was so excited, but I thought to myself, why do we have a 5-4 decision to uphold habeas corpus in the United States? It should be unanimous. What they're saying is an administration, no matter what their pretense might be, you cannot decide and run the law all by yourself. The decision is a I prosecuted people who committed heinous crimes. I sent them to prison, but I sent them within the context of our Constitution. And if we turn our back on our Constitution, where are we going to be? In effect, the terrorists would have won. They would have won. Think back to the days of the McCarthy era. Any of you are old enough to remember that. I was a child when that was going. I remember my parents talking about it. I've read a great deal about it since. How people ran in terror because of what Joseph McCarthy was saying. Because we had this threat from the Soviet Union, and we did face a threat. They were nuclear armed, we were nuclear armed. We were poised to strike at each other. It was a real threat. But Joseph McCarthy's idea of determining that was to ruin people's life, to roll back the First Amendment, freedom of speech, roll back freedom of association. He wanted to roll back the Constitution. And finally, a quintessential Republican businessman who had been elected senator from the state of Vermont, Ralph Flanders, decided he'd had enough. And he was a man of either party, the only one who had the courage to step forward and file a motion of censure against Joseph McCarthy. And then he was joined by Margaret Chase Smith of Maine. And then, finally, it came to an end, and America came to its senses. Well, I fear what this country would be if we did not protect our Constitution. You know, it is easy to stand up for the Constitution. Easy. It's important to stand up for it when times are bad. It's like free speech. It's easy to protect popular speech. The difficult thing is protecting unpopular speech. In this case, a majority of the court held unconstitutional provisions in the 2006 Military Commissions Act, which were designed to strip away all habeas rights from non-citizen detainees. Incidentally, I voted against that act. But the court ruled the constitutional right to habeas extends to Guantanamo Bay. They held the administration's detention procedures are constitutionally inadequate, and so forth. Well, the court's decision validates what I've always maintained. Congress made a grave error when it voted to strip habeas corpus rights and left in place hopelessly flawed procedures to hold detainees indefinitely. Stop and think for a moment. How many times have we, and rightly so, criticized countries that have held people incommunicado, indefinitely without charges? And we've been right to criticize them. How many times have we, as a nation, criticized countries that have suspended their form of habeas corpus, and rightly so? What do you think the image is of our great and good and wonderful country abroad when they see us do these things? What do you think it is when we find ourselves being lectured by Pakistan and Iran and other countries for doing these things? That's not the America I want. I want an America, I want to be able to reintroduce our country to the rest of the world doing the things we should do. Justice Kennedy, when he wrote for the majority, recognized that the writ of habeas corpus is not a special benefit to be honored only when it's convenient, but rather it's a core constitutional value that has served for centuries to protect individuals against unlawful exercises of government power. We have to protect our national security, but security doesn't come at the expense of our freedoms. I go to work every day in a building that was targeted for destruction by the terrorists. I go there proudly. I consider it an enormous privilege to be one of 100 in the United States Senate. And as the Supreme Court reminded us yesterday, security subsists too in fidelity to freedom's first principles. Chief among these is freedom from arbitrary and unlawful restraint and the personal liberty that's secured by adherence to separation of powers. I know you know that. I want you to know this senator knows that too. Thank you.